Good afternoon to everybody. Can you hear me?
Yes.
Good afternoon.
Yes.
Yes.
Okay. What we're going to do today is go on. It's both today and tomorrow. So the 3 lessons of this week are devoted to criminal law and procedure. Just to give you an idea, a general idea of how the various models in the Western legal system work, and what are the differences, the main differences, and somehow introduce you to certain important issues that you will meet when you go on in your studies. Now, what we were seeing yesterday was substantially seeing Cesare Beccaria's of Crimes and of Punishments, which is a foundational text for criminal law and criminal law reform from the mid-18th century onwards, not only in the European continental European systems, but all throughout the world. One always looks at Beccaria's, his ideas. They were mostly focused on what we would call substantive issues, but when it comes to the relationship between criminal law and the sanctions, well, that is something that is worldwide acknowledged as the basis of reasoning in this field. And I won't go more, delve more into it. I just suggest for those who are interested in this topic, just to read the book, and they will find, it seems, apart from obviously references to the 18th century, but they will find a whole lot of elements which are perfectly valid today. Now, what we're going to do now is just see what, as I've mentioned, can you see the slides? Sorry. Can you see the slides?
Yes.
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 Every now and then I'm not sure of that I've got the right technological approach, and therefore I'm sort of concerned that this whole system is working. Now, as I've already mentioned yesterday, we've seen that immediate results of Cesare Beccaria's book, which had enormous influence throughout Europe immediately, was the Tuscan Penal Code of 1786, and we've seen Articles 7, 8, and 9 of the French Declaration of Rights of Man and of Citizen of 1789, that is the ideological and legal basis of the French Revolution. We find these principles taken out, Articles 7, 8, 9, which are substantially taken out, extracted from Beccaria's book and put into this legal text. Now, I would like to point out that already at that turn of passing from the 18th to the 19th century, we have already seen somehow, we have compared, at one of our first lessons, we have compared the US Bill of Rights, 1781, but really done a couple of years before 1789, but in New York, but then it was enacted a couple of years later, and the French Declaration of 1789, so they're more or less in the same exact time. We've seen how these two foundational texts, legal texts of modern Western legal systems, approach the issue of criminal sanctions. And we've seen that the US Bill of Rights focuses more on procedure, and French Declaration more on substantive rights. Now, I just like to, as we are trying to compare these two models, we see this two approaches. The Anglo-American approach, British Bill of Rights 1689, US Bill of Rights 1791, the individual freedom from arbitrary interferences and accusations is protected by courts and by procedures. So the center of the system guarantees these guarantees come from the courts, from the judges. Now this has a very long history, but it is also very much related to the history, to the English history, and to the fact, this is the latest in the 1689, when we have 1689 Bill of Rights and the Habeas Corpus Act, the fact that the courts, together sided with Parliament against the king, when the stewards tried to somehow suppress a whole amount of liberties, well, the courts sided with Parliament. And so this gives the idea that the courts are defending individual rights. And this is a very long tradition that we have in England and then subsequently also in the United States. So we look more at the courts and at the procedures before trial and during trial. While instead in the continental European system, especially after the French Revolution, sorry, the individual freedom and freedoms are protected by Parliament, which establishes rigidly what is and what is not a crime. So the whole idea is that as Parliament represents the nation's will, and therefore it is the nation that decides if a certain behavior is or is not a crime, well, individuals are protected by Parliament and by the law. So this is two different approaches. On one side, the Anglo-American approach, protection is given by the courts. In the continental European model, it is given by Parliament. The European approach, therefore, is this principle of strict legality. We've seen it yesterday with this this Latin phrase, lex scripta, stricta, previa, et certa. So it must be written, it must be strict, therefore it is very worded in a strict and not in a somehow vague form. Previa, that it is before the fact is committed. If the law does not foresee a certain behavior as a crime, well, it cannot be retroacted, and certa means that it must be clearly established what is a crime and what are the sanctions for the crime. And the second element is that there is a monopoly in the production of criminal law, and this monopoly belongs to Parliament. It is the prerogative of Parliament to set criminal law and sanctions. So this is an essential aspect, and let's see if I can manage to move to the and this is we see that already some of these principles, we find them in the Napoleonic Code of 1810. Napoleon was a dictator, so he wanted to, and he was very much law and order, so he wanted, there's not many liberal ideas in the Napoleonic Code of 1810, but if we look at the Bavarian Code for Bavaria of 1813, we find Article 1 expresses these notions. Nullum crimen sine lege, nulla pena sine lege, nulla pena sine crimine, nullum crimen sine pena legali. So the whole, obviously all the Latin of the lawyers is there just to express the principle of strict legality. No crime without a law, and the law with a capital L. No punishment without the law, and the law again is a capital L. Nulla pena sine crimine. No sanctioned without, if there's no crime, so there cannot be a sanction if there's not a crime. And finally, there can be no crime if the sanction is not legally imposed. So just to point out this idea of strict legality, which enters into the continental European system from the beginning of the 19th century and remains then this center of criminal law. When you will study those Italian students who will be studying criminal law, they will see that these principles are still there. But if they were in Germany, they were in Spain, in Argentina, or in Japan, they would find more or less these same principles. And also the idea that the enforcement of criminal law is something that is given to the courts. Now, this is a move towards the idea of justiciability, which we saw in Beccaria. It is up to the courts to decide if someone is guilty or innocent. It is not up to other authorities. It is not up to the king and his bodies. It is up to the courts, to a third party that has to decide who is guilty or who is innocent. While if we look at the US, I would focus more on the US because the developments are very more sweeping in the US than they are in Great Britain. That criminal law and criminal procedure are a constitutional matter. Now, this is very important. Obviously, other countries did not have a constitution. At least they did not have a constitution as we feel, as we mean a constitution today, and as it was already perceived in the US. So the US was a country with a constitution, and immediately the issues of criminal law and procedure become a constitutional issue. Why? Because if we look at amendments 4, 5, 6, 7, 8 to the US Constitution, that means 5 out of 10 of the first 10 amendments, they're all devoted to procedures. Just think of searches and seizures in Amendment 4, and or to substantive issues such as proportionality in punishments and no cruel and unusual punishments. And so what happens that if we want to study the history of criminal law and procedure in the US, we necessarily have to study constitutional law, and we see all these hundreds of decisions of the US Supreme Court that have come up throughout the centuries, these 2 centuries and more than 2 centuries, and that shape the US criminal law. Just to point out, and this is very important, although the US is a federal system, please remember that the US Supreme Court, when it takes a decision, this decision is valid not only for the federal institutions and the federal courts, but it's valid also for the states of the United States of America. So it shapes not only US federal law, but the criminal law and procedure, but also the criminal law and procedure of the states of the US. So this is a very important aspect that we have to consider. So criminal law becomes a constitutional issue. Second issue, remember that there is this principle set out in Article 6, Amendment 6 to the US Constitution, that there is a trial by jury. Now, this is very important. It was already set, somehow expressed in Beccaria, but this is a long tradition which comes way back from the Magna Carta, the idea that you should be judged by your peers, by people who are your equals. It is not simply the judge, but it is the community which decides if you are guilty or innocent. Now, this is very important because this introduces in the American judicial system the notion of a sort of the jury, where we the people, we've seen that we the people elect the president, we the people elect Congress, so we have the legislative body, the executive body, which are elected by we the people, and we the people are sitting in court in the jury, because they're simply extracted. The members of the jury are selected by chance. They're in a list and they're just extracted. And so the members of the jury are members of the community, and therefore this is somehow a way, at least seen by the founding fathers of the US Constitution, as the sort of the democratic control over the administration of justice. Surely there's a judge in court, but the decision, and we shall see this in a moment, the decision on if someone is guilty or innocent is left to the jury. And again, further element which is very important in the American system, the role of evidence. Evidence of guiltiness of the accused person, and this principle beyond a reasonable doubt. So you have to go beyond the reasonable doubt. If there is a doubt, the principle is what I wrote down yesterday, in dubio pro reo. So if you are in doubt, surely the accused has to be acquitted. So in order to declare that the accused person is guilty, you must go beyond the reasonable doubt, and therefore the importance of evidence, which must be shown and understood by the jury. So this gives you we've seen different aspects in continental European systems and in the US system. We've seen these different approaches and how, and now we try to put them together. So this is one point I would like to make to you, because this is quite common in continental European systems, and the idea that you study criminal law, substantive criminal law, pretty early in your one's law school, law faculty curriculum, and then subsequently later on you study procedure, criminal procedure. Or in the US you see a first semester course, it's criminal procedure. So keeping these two aspects separate, I'd just like to stress this point which I already made yesterday. Criminal law is effective only when it is enforced. Otherwise, it is only in the books. Clearly, we generally, most citizens abide by the law, and therefore, for most of the citizens, the criminal law remains in the books. But when we want to see to what extent, what is the real import of a criminal law, we must test it. And the only place to test it, to see if it is effective, is to have a case and have a case in front of the court. So criminal law does not live in the books. Well, its general preventive, dissuasive function is in the books. I know this, I must not steal, I know I mustn't kill, I know I mustn't organize crime, and so on. So I know these things, but this will remain in the books. When I want to see what is the life of a criminal law, how it works, how it affects society, how is it, does it function in a society, I need a trial. And therefore the two aspects, the substantive aspect, the provision which is written in the text of the law, and the trial, and therefore all the procedures, are two sides of the same coin, and therefore one cannot exist without the other. So just to point out this, that whenever sort of we analyze some criminal substantive aspect, we immediately must try to understand what are the procedural consequences of this. For example, how you can collect evidence. Can you collect evidence in a certain way? For example, I'll just make a rather common example from today's, from contemporary criminal law. Can I use digital technologies? Can I use special spywares? Can I inject a spyware in the mobile phone of the suspected person in order to understand and to record all his or her conversations, not only on the phone, but all in the environment in which that person is? Obviously, this depends on the kind of crime. For serious crimes, I can do it. For petty crimes, I cannot do it. So immediately, this has an influence on the evidence that can be brought to court in order to declare someone guilty. So always, when we look at substantive criminal law, we have to look at the procedural rules, and at the same time, when we look at the procedural rules, we must try to understand what is the role of these procedural rules in respect of the substantive provision. I mean, does it make sense to have a trial by jury if there is a very petty offense? Obviously not. So you have to try to understand what is the relationship between these two aspects, substantive and procedural. Now, whatever the differences, and there are significant differences in the development of these two models, the whole idea that has been around which we have been working in continental Europe for the last 2.5 centuries, in the Anglo-American system since Magna Carta, that is 8 centuries, the whole idea is that individuals have to be protected from abuses of power by the state, once upon a time the sovereign and his officials, and now other forms of intervention by the state, typically the police, but not only the police. So the whole idea is, where does the protection of the individual lie? And if we look at the development between of these two systems, of the Anglo-American system and the continental European system, we see that growingly these guarantees move, procedural guarantees move from across the Atlantic to continental Europe, and vice versa. Substantive guarantees move from continental Europe towards the US, just to show how much dialogue there is in these fields. Now, problem is, we've been talking until now of generically criminal law and procedure. And so when we talk about criminal law and procedure, we suppose there is a crime. The problem is, what is a crime? Now, the question is not idle. The first, I'd like to remind you that one of the main consequences of Beccaria's book is finally the sort of very clear separation between sin and crime. What is a violation of a religious rule, and what is the violation of a rule which is set by the state? So first point is, in the 18th century, we've already separated what is a religious aspect, very important for believers, but what is a sin, from what is a crime that is a violation of the law set by the sovereign or by the authorities. Now, when we say what is a crime, this issue is relevant also today because we see that owing to this enormous amount of work, of development that we've had, 8 centuries in England, 2.5 centuries in the US and in continental Europe, of developing guarantees for citizens, for first subjects and then citizens, against abuses of power, we see that when there's a crime, or rather the accusation of a crime, the individual is somehow protected. So we have created a whole lot of protections. US Constitution, amendments 4 to 8, and then we see that in contemporary constitutions, whether it is the Italian, the German constitution, or other sort of Western constitutions, a whole lot of guarantees are given to the person who is accused of a crime. So this is, so we need to know what a crime is when we are facing a crime, because in that case we have certain guarantees. If it is not considered a crime, then we do not have these guarantees. So this has very much to do with what you students are studying, sort of partitions of the law. So we start looking, we enter university, for us the law is something, you know, very confusing. If anything is the law, and then we start seeing that we started putting order in the law. And we progressively understand the difference between private law and public law, and then procedural law and criminal law and so on. So understanding what is a crime is part of, well, obviously of legal education, but also has significant consequences on what in the protection of individual or private interests is can be afforded when we are facing a crime. If we are not facing a crime, well, maybe we don't have the same kind of protection. Now, just to point out this, sort of originally, even sort of my times when I was studying law, like you are, well, the traditional distinction is between civil wrongs. Just think of non-performance of a contract. Someone has not paid what he or she should have paid, and therefore there's non-performance of a contract, or a tort, extra-contractual liability. Someone drives carelessly and runs over a pedestrian who is crossing on the street on the pedestrian crossing. So just think of what are civil, that is a typical civil wrong, so non-performance of a contract or an extra-contractual liability, and then we find a whole series of remedies, traditionally damages and restitution, and then we have injunctions, various injunctions to do something or not to do something. And on the other side, so this is on one side, originally we have this distinction, civil wrongs, and then we have crimes and sanctions. What are sanctions? Imprisonment, confiscation, fines. So we see very clearly this distinction. Now, this distinction, it was sufficiently clear, not that they weren't other sanctions, but these other sanctions were not really very much considered. They existed, but they were not so important in the structure of our systems, and especially when we were studying law. Now, instead, what happens? I just want to bring you back to the part of the course where we examine the expansion, the great expansion of the powers of state and public authorities in the field of the economy and in the field of sort of social organization, welfare state. That could be also one aspect. So what happens is that increasingly the state has, in order to enforce this enormous amount of legislation it has in the field of administrative law, it has imposed administrative sanctions. And these administrative sanctions are, not only they have grown and grown and grown, but are very, very strong, very effective, and can be very harsh, even harsher than criminal sanctions. So this is we see this immediately, a situation in which the real sanction are administrative sanctions and not criminal sanctions. Just think of an example, withdrawal, suspension or withdrawal of a license. It could be a driving license because someone has been driving under the influence of alcohol or drugs, so the license, but it could be withdrawal of the license for any kind of economic activity, commercial activity, or the closing of premises. Just think of a restaurant, the police goes there and finds that the food that is given to the clients of the restaurant is no longer fresh and therefore could not be given to the clients, and therefore there's a risk of food poisoning. So the restaurant is closed. Or a company which is suspected of some kind of connections with organized crime cannot perform certain contracts. And extremely high fines are imposed on, administrative fines are imposed on those who are on the wrongdoers. Just think of the cases of competition, violation of competition rules. Just imagine a cartel between producers of a certain product who agree in somehow the price, the minimum prices. They say, well, we will not do less than a certain price, or they start subdividing geographically the markets. Well, if this cartel is discovered, well, there will be very, very serious fines, which are in proportion with the total turnover of the company. So if the company has 10 billion euros of turnover and say up to 4%, well, that makes it an enormous amount of money that is of fine that is imposed on the company. So just to show you that these administrative sanctions are often much more effective, much more dissuasive than criminal sanctions. A company is not so much afraid that the manager will be somehow charged with some kind of crime and therefore will be tried, but that will take time. And what the company is afraid of, that it will not be able to do certain activities, maybe be suspended from the stock market, it won't be able to trade its shares, and so on. So just to point out that these administrative sanctions are very, very heavy and very dissuasive. And so when you enter a company, immediately a company is concerned, obviously, of not committing crimes, but not committing violation of the enormous amount of administrative rules. Do we have the principles of lex scripta, stricta, previa, certa apply to administrative sanctions? This is one of the core issues of contemporary legal systems, because we are talking of administrative sanctions, not of crimes. If it comes to crimes, we are sure that it will apply. Those principles will apply, and especially also the principle of strict legality will apply. Therefore, only Parliament can, by law, these sanctions can be introduced. But when it comes to administrative sanctions, are we sure? So what happens is that there's, in our view, a crime is the most serious offense against the law and against the order of a society, but those who violate criminal law have much more guarantees than those who violate an administrative rule. So in our idea of the scale of values, we think that when the value is very high up, it is protected by criminal law, and if it is lower, well, we protect it with some kind of administrative sanction. Here we see that the proportion is, there's disproportion between administrative sanction and the criminal sanction. So this is a very complex issue. I just to put you on this kind of problem, because it is one of the points in which there's enormous amount of debate in Europe and in all Western countries. Just to point out, just make an example. I'll take it from competition rules. Now, what is competition law there to do? It is there to somehow protect the market and the good functioning of the market. So what you must do, you must ensure that the companies compete and do not collude, and that a company does not take advantage of its dominant position. Let's focus on collusion between companies. Now, surely the market is very important. It's a very relevant interest in the market, but we somehow think that maybe life and property, individual life, limb, personal safety, and property are more important than the functioning of the market. However, when it comes to sanctions against collusive behavior by companies, what are the powers of antitrust competition authorities? Can the competition authorities send police to a company and order that company to hand over certain documents? Yeah, the obvious reply would be, if the police, I have just killed someone, and the police comes over to me and tells me I must hand the gun or the knife with which I committed the crime, I say, I don't know, I did not commit the crime, and I have I do not have the knife or the gun with which I committed the crime. So the principle of nemo tenetur litigia, the Fifth Amendment to the US Constitution. Nobody can be forced to self-incriminate himself or herself. When it comes to these administrative procedures, does this principle of non-self-incrimination, is it valid? Is the fact when the police goes to, or the inspectors of the National Competition Authority go to a company and say, I want to have access to your computers, I want to have all the papers, I want to seize all the papers which concern this certain practice, must the company provide these papers, or can the company say, sorry very much, there's no judicial order, if when it comes, I can hand over these, I will hand over these documents if there's a judicial order. You do not have a judicial order, I will not hand them, because I cannot be forced to self-incriminate myself. So just to point out that this is a very delicate issue, because it shows that when we increase the powers of intervention of the state in the field, mostly in the field of economy, but not only in the field of economy, and we have sanctions, and we decide we want to have administrative sanctions, not criminal sanctions, we somehow have to understand what are the guarantees that are given to citizens and to business entities. Just to open a window on a very broad perspective, which becomes more and more important in our contemporary societies. Now, let's go. Now, let's go back to the question, when do we have a crime? It is so a crime, you can't distinguish a crime on the basis of how harsh, how heavy the sanction is, because we find that many administrative sanctions are much heavier than criminal sanctions, but generally are in front of a crime when the law establishes that the sort of the decision on whether there is or there is not a crime must be taken by a criminal court. So it is the place where the case is decided that establishes if it is a crime. If the place where it is decided is not a criminal court, with all those guarantees that we have seen concerning how the trial must be conducted, what are the rules that have to be applied, and so on, well, we're not in front of a crime, but we are in front of some other kind of violation. Some violations will go in front of an administrative court if there are administrative courts, or they will go in front of an ordinary court, which is not a criminal court. So just to point out that this is something that you will, when you will study, I'm talking to our Italian students, when we study sort of criminal law and administrative law, you will have to try to put these two aspects together. Now, let's try to understand what are the sources of criminal law. I will somehow simplify certain aspects by remembering that in this very great tradition, which is the English tradition, then the US tradition, there are so-called common law crimes. The crimes that have always existed, and maybe there's some very old principle that has been established way back centuries ago, but in the meantime it has become part of a rule that has somehow been forged by the courts that have been working in England for the last, well, many 10 centuries, and in the US for the last 230 years. So, but I'll set these aside, sort of rules that have been elaborated by the courts. And I will focus on sort of on written legal instruments which set a criminal law, because there are certain sanctions and violation of these laws are brought in front of a criminal court. Now, in the continental European system, well, the source of criminal law is the law with a capital L, which is a formal act of Parliament. Just to remind us, always to remember, in continental Europe, that this principle of strict legality. Yet, I'd just like to warn you, and but this you will be studying this, our Italian students will be studying this when they study criminal law. Well, not every element of the crime is set by Parliament. We find that in many cases, the certain fundamental, essential elements of crime are set from outside the law. It is some kind of, I would say, administrative piece or normative decision which establishes if that is a crime or not. Just think of a list of narcotics. Just take very simple. Sort of someone is smoking marijuana, joint, cannabis. Now, well, how do you establish if that what someone is smoking is a narcotic or not? Well, obviously depends on certain standards, certain technical, chemical standards, which are set not by Parliament, but by some other authorities, medical health authorities, which have established when a certain substance can be considered a narcotic and when it is not a narcotic. Just think of all the shops of the sort of hemp cannabis shops which have sprung throughout Europe, in Italy and other countries, and also the US, where they sell, well, it's cannabis, but it does not have that narcotic potential. So obviously this is not the level of toxic substances is set not by Parliament, by someone else, let's say the Ministry of Health. Or just think of what are the forbidden substances in foodstuffs. Are you allowed to put certain substances that are used to color foodstuff, red, purple, yellow, or does this become a crime because it endangers public safety? Obviously, there is a list of forbidden substances that cannot be used in foodstuff, and this list of substances is not set by Parliament, obviously, but is set by some administrative authority, again, typically the Ministry of Health. So just to remind you, that even in systems where there's this principle of strict legality, a crime is a crime when it is set by, when its elements are set by Parliament. Not all the elements, often not all the elements are set by Parliament, but are maybe set by some extra parliamentary source, generally obviously an official source which establishes if that some elements of the crime are existing or are not existing. In the Anglo-American model, instead, what we find that the criminal sanctions can be imposed not only by obviously Parliament, Congress in the US, but also by local authorities and by administrative agencies. So we see that the power to impose criminal sanctions, that brings to typically arrest, well, these can be somehow imposed by, some administrative authority or local authority that imposes these kinds of sanctions. The example that I've already made to you, you go in the New York subway system, which is one of the most dirtiest subways in the world, and if you compare them with the subways of other countries, and you find wonderful carriages which are very clean, everything's neat, everything's. But in the US, in New York, if in New York City and you're tired, you're getting the subway in the evening, and you want to rest your legs because your legs have been walking all day around, and you want to rest your legs, and you put your feet on the seat in front of you. Well, and some officer of policeman, that is a policeman of New York City, or some official, the guard of the New York Transport Authority, sees you there, well, you will be arrested, because there is a provision set out by the New York City Council, which establishes that if you put your feet on the seat in front of you, you can be arrested. Now, this makes, obviously, you just understand, you say, well, this is, well, obviously, people should not somehow spoil public property, and surely we want subway carriages or train carriages to be clean, but in most other countries, we see that this is simply an administrative fine. You've done something that you shouldn't have done, and you will, just as if you haven't paid a ticket, and you will receive a fine. That is an administrative sanction. You will not, your freedom, personal freedom, will not be taken away from you just because you have done this because of this wrongdoing. So just to show you that this, in establishing which are the sources of criminal law, is very important, because this has to do with this idea that who holds the keys to to establishing what a crime is, and to criminal sanctions. Now, I just think we can just do 1 second. Just let me. Are there any questions on this first part of the lesson? Sid is asking, can you repeat what is the meaning of the principle beyond the reasonable doubt? Now, we shall see this in a moment when we're looking at who takes the decision in a criminal court, whether it is a professional judge or it is a jury. But the idea is this. Just remember what Beccaria was saying. We have the sovereign that has set certain rules, the subject who is accused of have violating these rules. The decision is given to establish if this accused person is guilty or innocent, is given to third party, the judge. Now the judge has to decide on the basis of the evidence that he has whether the accused person has or has not committed that crime. Now just think of, let's take a typical example, a murder. And someone is accused of a murder but has not been there's circumstantial evidence. So that person, well, yes, that person was somewhere in the surroundings of the place where the crime was committed. So he did not have an alibi. Alibi is, again, nice Latin expression, means elsewhere. So the accused person was not elsewhere. So that person, well, he was seen around the crime scene more or less the time in which the crime was committed. There were reasons, because the person had had an argument with the accused person, with the victim, with the person had been killed, and then maybe the person, there are some fingerprints of the accused person that he or she left on the crime scene. So the problem is, well, do we have, what are the doubts? Obviously, the defendant, the accused person, his lawyer will start saying, well, yes, he was there because he lived there. Well, yes, he had a grudge. They weren't friends, but he is a quite peaceful person, a peaceful citizen, and he would never have killed anybody. There's no story of violence by him. There's no reason why he had an argument with the deceased person, but there was no real reason to kill if you kill all the people with whom you disagree, well, obviously this is not the normal reaction. So it is not obvious that having had an argument means that that person, he is the culprit, he is guilty. And thirdly, well, there are his fingerprints, very simply because he went there to complain, and with this person, this is the moment in which he had the argument, and he left his fingerprints there. So the defense lawyer is trying to put a whole series of doubts on the fact that that accused person actually killed the deceased person, while the prosecution will try to bring evidence saying, well, all these elements, these doubts that the defendant is bringing along are not enough. They're not solid, because I can show you that not only this person was at in the surroundings, but was exactly in that place in that moment. Well, we don't know, because I can control his mobile phone, and I can tell you that he was in that building at that moment when the crime was committed. So, well, that is that's a strong piece of evidence. Then there are witnesses. I will bring witnesses who remember this very clear phrases of the accused person saying, oh, you're going to pay for what you did. Yeah, I'm going to show you that you're not going to get away with it. And so very menacing phrases. And thirdly, I will bring evidence, forensic evidence, showing that the fingerprints that were left there were fingerprints of them left not previously. They were not left day before the crime or much time before the crime, but at the moment when the crime was committed. So the problem is clearly the judge, whoever has to decide, or the jury, has faced with two versions and must reach a verdict and beyond the reasonable doubt. Now this is, I tell you, we know much more about US criminal law. I suggest if you're interested in criminal law, you just look at it, as we are all confined at home, you have a whole list of Law and Order. I suggest you read Law and Order, you look at Law and Order, which are perfect. There's not one element which is not correct from a US legal system approach. Everything is perfect. So you can, you probably know, we all know much more of US criminal procedure than we know of the criminal procedure of our own countries. Just to point out that this idea of reasonable doubt is the fact that there's someone that must decide and must put aside reasonable doubts on the fact that the accused person committed the crime, and must be pretty, not completely sure, because when it's circumstantial evidence, you are never sure 100%, but you're pretty well sure that that person did commit the crime. So I hope this clarifies this idea of reasonable doubt. I just would like to make an example. Why we find this very important principle in criminal law. And we find it more or less in all legal systems. When it comes to civil wrongs, to extra-contractual liability, just think of someone who has a doctor who has done something wrong, and the patient is died as a consequence. Well, we will not use the principle of reasonable doubt, but we will use the principle generally in most systems. Just let me get the, sorry. This other, when it comes to a civil wrong, a private wrong, it could be a traffic accident, it could be medical accident. We will not apply the principle of reasonable doubt, but generally speaking, we will apply the principle of preponderance of evidence. So it's more yes than no. Why? Because obviously in the first case, we have what is at stake is the freedom of the accused person, who, if found guilty, may go to jail, while in the when there is a civil wrong, when there's a private wrong, well, the sanction will be damages. Damages may be very heavy, but the whole idea is a different standard of evidence that we will apply in a civil wrong as opposed to a criminal wrong. So I hope that this makes it sufficiently clear also in comparison with other branches of the law. Generally speaking, in private law, when you will study extra-contractual liability, or those who already studied it, well, we see that the standard is of evidence is much lower than in criminal trials and procedures. Now, let's move on to another aspect which helps us compare criminal sanctions. Now, the problem is this, that once upon a time, well, it was, let me see. No, sorry. I've gone to just let me, 1 second. Okay. So, criminal sanctions. First element. Who can be sanctioned and how? Immediately we see that, for example, when it comes to juvenile delinquents, minors, under a certain age, depending on what country it is, could be 12, 10, 12, 14, well, it depends on each system. Well, generally we have juvenile courts and sanctions. So we have the sanctions which are tailored on the identity of the wrongdoer. So if the person who has committed a crime is someone who's young, and somehow we believe generally they can be rehabilitation, well, there will be some kind of sanction. And when instead it is someone who has full of age and is a grown-up, well, we have typical sanctions. So this is the first element, which you should keep in mind. Second element, when they are incompetents. We shall analyze this further on when we're looking at delinquency. Sort of what we have when someone is a madman and has committed a crime, well, obviously one will not apply imprisonment or other kind of typical sanctions, but generally one will have mental health institutions that should somehow detain, in which the person can be detained. Will the person, someone who is incompetent, will be acquitted from the crime, will be held not responsible because the person was incompetent, because this person did not have the mens rea, did not have that element of intent that allowed him to understand the difference between what is wrong and what is instead is evil and good. But there will be some kind of social protection by committing this individual to a mental health institution. So again, here we see that the sanctions, they are sanctions, but they are not, strictly speaking, criminal sanctions. Then, third element I want to bring your attention to
until, well, let's say 20, 30 years ago, there was this principle that societas delinquere non potest. The idea that legal entities, mostly companies, could not be subject to criminal law. So who was liable? The manager was liable of the entity. So what happened when some company was going into some dubious activity, what they did, they designated somehow a straw man, a stooge, someone who was, let's say, well into his or her 80s, named this person as executive officer of the company, or manager of the company, and this person formally took the decisions, but these decisions were suggested by someone else. If something happened, then, well, there was a criminal accusation against a trial against this elderly person, but obviously the person was elderly and obviously could not be sent to jail. So this was a way to avoid criminal sanctions. So the company stayed there, and at the end of the day, nobody went to jail, or nobody was sentenced, or it was very distant from dissuasion. Now, we have seen that increasingly, with the control of the state over economic activity, well, we have typical company crimes. Crimes which are committed by companies, generally in order to make bigger profits, and therefore, but with harm generally to the general interest of the community. Just think of pollution. When there's a company that simply carefreely throws poison waste in the river or in the land, and this creates pollution with danger for future generations, for the environment, and so on. So yeah, that's a typical case in which the company itself will be sanctioned, or bribery, company that generally uses corruption in order to obtain public contracts, or unfaithful financial reports. Managers present false financial reports to the financial authorities, go to the stock market, and then investors are defrauded. Or just think of data protection breaches or violation of worker safety. So we find a whole lot of crimes which are very important in contemporary criminal law, by which the company itself is sanctioned. And obviously this means that we will apply certain sanctions. Obviously you cannot get a company and put it to jail, but you will do something which is much more effective towards that company. We shall see it in a moment. So first point is that sanctions are somehow tailored on the accused person or entity. If it is a minor, we will have certain kinds of sanctions. If it is an incompetent, other kinds of sanctions, but they're not considered sanctions. They are somehow measures to preventive measures to prevent this person from harming other people. Or if it is a legal entity, obviously different kinds of sanctions. Then we have also that the sanctions have been changed, not only subjectively, adapted subjectively, but also objectively. Because originally, what did we have? Death penalty, obviously, imprisonment, confiscation, exile, fines. These are typical sanctions that we find in the toolbox of criminal law. We found it in Hammurabi's code way back in the 18th century before Christ. And we've been using these, in this toolbox, we've been using these for thousands of years. So we have not given up those sanctions, except if you want exile and death penalty in exile in all countries, but we could have we wouldn't talk of exile, we would talk of expulsion. If a foreigner commits a crime in a country, well, one of the consequences is that they've been expelled. So you see that this is somehow still exists. And then a death penalty that has been abolished in most Western countries remains in certain amount of US states. But this is the original toolbox. If we look at the toolbox that the criminal courts have today, we see that this toolbox has sanctions which are adapted to the nature of the crime and to the perpetrator. Just principle of restitutio in integrum. Let me put this nice phrase, let me put it in italics, so we just to remind ourselves that we're talking of Latin. So you have to put things back as they were. Now this makes, well, when it comes to an individual, well, generally, well, it would be compensate for the damage it has done. But I just think in the case of pollution, what is the sanction? The sanction is reclamation of the polluted land. The company will be sanctioned, sentenced to reclaim the polluted land. So it's not so much or to give the money in order to reclaim that land and to eliminate the result of the pollution. So this shows you this is a very common sanction. Or disgorgement of profits. It has made illicit profits. Well, those profits must go back to those who have been damaged. So just to point out that we are growingly sort of adapting the sanctions. They're no longer only the ones of the traditional toolbox, but also new kinds of sanctions, and the legislators sort of think of new kinds of sanctions which they feel are much more effective. And also we find when it comes to individuals, for example, alternative sanctions to imprisonment. So instead of sending someone to jail, you say, well, you will do socially useful activity. We've had cases in which sort of elderly politicians who could not be sent to jail have been sentenced to do socially useful works in certain structures for old age pensions. So just to point out, or people who are sort of should clean the streets or do other kinds of socially useful activities. So that is alternative measure, or house arrest. No longer prison, but you have to house arrest. Now we are all in house arrest, so it's rather amusing the fact that somehow those who were apparently were under house arrest are in the same position as us, or we are in the same position as them. But this is just to show us what are the unintended consequences of this lockdown. But just to point out, house arrest, instead of sending a person who's been guilty for a crime, this person cannot leave the house and must remain in the house with a whole lot of limitations. Further element, which is very important that we use when we're looking at criminal law and then we are trying to understand different models. Sentencing. So, okay, someone has been found guilty of a crime. Now, what is the sentence that will be handed out? Who will hand it out? Is it handed out immediately by the court, by the judge, or is it something different? Generally speaking, in continental European systems, we see that the sentencing, that the decision is at the final decision of the court. When the court comes in and decides that the accused person is guilty, then it will has already established what the sanction is. In other systems, typically Anglo-American systems, well, it's separated. The person is found guilty, and then subsequently, in the second moment, the court or the judge will establish what is the sanction that has to be handed out. So this is also important because it's established who is deciding on the sanction. So we find someone who's deciding on innocence or guilt of the accused person, generally the jury, and then second moment we find a judge, generally a professional judge, who is there to hand out, deciding what is the sanction that must be given. Just take a rather famous trial that finished less than a month ago, the Harvey Weinstein trial in New York against the former movie producer. Well, he was found guilty of rape and sexual assault by the jury, and after certain amount of days, well, the judge, the professional judge, came out with a sentence, I seem to remember, 35 years of imprisonment. So just to point out that this shows a distinction in system. Then, to what extent can there is judicial discretion in establishing the amount of sanctions on the basis of objective, typically seriousness of damage? Person who has killed one person, has a fit of rage, has killed someone, or someone who has killed 10 people. Well, obviously we will, this is an objective element that you will take into account when the person is sentenced, or subjective elements, the intent. Was it carelessness or was it malicious intent? Was it premeditated? How did the guilty person behave? So just to point out that, again, we are interested when we compare sentencing, how sanctions are applied. We're interested to understand how the courts will apply and what are the criteria that the courts will apply when sentencing. And then, just to conclude with on this point, on a rather sorry, here this has take this away. Okay, an issue which is very significant. It's in the US, but not only in the US. What do we have? We have this so-called, we call it, quote unquote, algorithmic. I better put inverted commas here, just to make it. Algorithmic sentencing. What is the issue? In the US, they've discovered that well, most criminal law belongs to the states, so we have 50 criminal laws. But what happens is that if you kill someone in Alabama, well, maybe you'll have a different sentence than if you kill this person in Alaska, just to take the two first states in the list of the US states. So, so in order to avoid this kind of, so the fact that the same kind of crime, someone has killed his wife or vice versa, the wife has killed the husband, well, you will have a different kind of sentence, well, with the same legal provision which establishes the same kind of maximum and minimum range of sentences, well, one is introducing what is called algorithmic sentencing. So a system that should aid to create, to issue an ordinary and not extraordinary sanction, which is somehow takes into account all various elements. Now, there's a lot of debate about this and has to do with algorithmic justice, the sort of the judge being substituted by some kind of computer program, well, as many of like all algorithms, it works on a database. The problem is the database collects data from prior cases of sentencing and therefore collects also elements which have intrinsic bias. This is very common in the US, where we know that a certain kind of, if we look at the delinquency rate, we see that it touches certain groups, social groups, or certain ethnic groups more than others. So this becomes somehow racially discriminatory. So if I'm black or I'm Latino and I commit a crime, I risk receiving a higher sentence than if I'm a WASP, a white, Anglo-Saxon and Protestant. Just to point out that these are very complex issues, I just wanted to introduce you to the issue that algorithmic sentencing is a very strong debate. One understands that one wants to have uniformity in decisions, and one wants to avoid that there are different decisions in Alabama and in Alaska, but at the same time, one wants to ask oneself whether an algorithm can be a good judge and not a biased judge. And finally, just to conclude here, and we'll finish here for today, anticipatory sanctions. Originally, what did we have? We had, with a sanction is issued after the trial and before the trial, well, only there's imprisonment, only there's danger of that the accused person will escape. Now, with this growing role of the state, which controls society, economic activity, and general societal activity, what we find a growing amount of sanctions which are introduced before the trial, and which are very effective sanctions. Typical example, freezing of assets. Someone is suspected of being somehow involved in organized crime, in money laundering, in international terrorism. His assets will be freezed. That means that all his economic substances, his bank accounts, his estate will be blocked. He cannot dispose of this, his assets. Now, this is very, very effective, or preventing something going on in financial transaction, or just think at a more common, unfortunately common case, the fact of sorry, just one second. The fact of stalking prevention orders. Someone is accused of stalking, and it's a man who is stalking previous spouse or the partner, and there are prevention orders. Someone must stay away from the former partner 1 mile away, and so on. So you have a series of sanctions which are imposed before the trial. And finally, and we'll conclude with this, so-called reputational sanctions. Now, these are not written in the law, where once upon a time they were also, well, sometimes some laws there's written that judicial decision should be made public, but here we have increasingly in our society, which are media societies, information societies, this notion that naming is shaming. So when someone is accused of having committed a crime, even before the trial, this person is somehow shamed in front of the community. Someone has been, a suspected professional has been accused of corruption or of sexual harassment. This comes out on the media, and the person is immediately shamed. So everybody will remember that the name of that person, say, hey, yes, he was accused of having corrupted have tried to bribe a public official. So just to point out that this is, and has very much to do with the interaction between justice and media. And obviously, as you know, the internet forgets nothing. By now, anything that goes on the internet will be there for all your life, even when someone has maybe done something stupid when he or she was in high school and that news came out, well, that will remain on the internet for decades and decades, and maybe will have negative consequences in 20, 30, 40 years. So just point out this, that the relationship that there is today between criminal justice and media and social media, and it is not an irrelevant aspect we should consider. For today, I would stop here, but obviously, any more questions on the topics we discussed today? Dominique Antonio. Yes, what did you want? Oh, algorithmic sentencing. Yes, okay. Now, take a very big country like the US. US has 330 million inhabitants. It has system is a federal system, therefore there are federal crimes. When you look at so a legal thriller or a legal series, the feds are coming. So the federal crimes, those crimes which are set by Congress, take for example counterfeiting money or drug smuggling, or some kind of very serious organized crime. So we have federal crimes, and then we have state crimes. Now, each state in the U.S. has sovereignty in establishing what are the crimes and what are the sanctions. Although there are model penal codes in the U.S., and therefore, generally speaking, there are the same kind of behaviors, typically, let's imagine murder, well, there can be differences, significant differences in when it comes to sentencing. So what do we have? We have a jury that finds the accused guilty, and then we have a professional judge who is sitting there who must establish what is the sentence to which the person must be sentenced to. What is a sanction? And let's set aside the states where there's death penalty, because obviously there's no, well, death penalty, there's no proportion. I mean, someone has been sentenced to this and that. But let's imagine prison. So there's a range for certain crimes between, let's say, 5 years and 25 years. So very wide fork of options left to the judge. Obviously, this depends on objective elements, seriousness of crime. I mean, how serious that specific crime was. I have subtracted, I've stolen money. I'm a thief, but I have stolen 1,000 euros, $1,000. Okay, I'm a thief. I went I was a cashier of the bank, and I stole $1,000 from the cash of the bank where I was working. I'm a thief. Okay. I've stolen $1 million. Hey, well, that makes a difference. I mean, so there's an objective element. Or subjective elements. Think of the case in which someone has committed a crime because there's been a furious quarrel with someone, and in a fit of rage, someone extracts a pistol and shoots. Or someone who has premeditated the crime, said, how am I going to kill this person? And so finds all the scheme and thinks it over, 1 month, 1 year, 10 years, how to kill this person. So these elements will somehow influence the amount, whether it is 5 years or 25 years. But once we have done this, when we have two exactly the same cases, someone who has stolen $1 million, he is a businessman who has collected a lot of money in Wall Street, collected $1 million and has stolen that $1 million. Now, or this person has done it in Los Angeles or has done this in Denver, Colorado. Now, how do we establish somehow an equal sentence for these people who have committed exactly the same crime, and we have exactly the same factual elements? Clearly, it isn't that sort of the California judge can call his New York colleague and saying, hey, listen, I have a case just like yours. How did you decide your case? So just think of a judge that has to decide and doesn't remember in the US, the judge or the court decides the sentence after the trial, after the jury has come out and declaring that the accused person is guilty. So there's time. This person, the judge or the court, has time to decide what is the exact amount of the sentence. Let's limit ourselves to imprisonment. 5 years, 10 years, 15 years, 20 years, so on. Now, one of the solutions that the Americans have tried to implement is saying, well, listen, why don't we do a database of all cases and we see what are the main elements in sentencing. So we look at objective elements, subjective elements, and so on, and we will put this in a system which somehow comes out with a certain result and tells us what should be the ordinary decision taken, the ordinary sentence that should be taken. In this case, it's surely 5, the minimum. In this other case, it's surely the maximum, let's say 25. But, you know, in the mean, between the two extremes, what is the decision that should be taken? So you pour in a whole lot of factual elements, you fill in a whole lot of factual elements, objective and subjective and so on, and then you see what comes out and what is the average sentencing in the US. Now this should guarantee the accused person of not having something that is, you know, there's a personal grudge, sort of the judge who is being part all the time, but has a very bad opinion of the accused person and says, well, now I can make him pay for it, how he behaved in court, how he was disrespectful, or I think he really is a nasty person, should be sanctioned. So somehow this is a way to somehow protect the accused person. But on the other hand, well, we know, because the history of certain crimes, typically certain crimes, well, they're committed by certain ethical groups. So what you want to do is you must avoid that these algorithms somehow have a bias inside them by which they will, the result will be that obviously if you are an accused, if you are Latino or you are black and you are and you're accused, you will get a higher sentence than if you are belong to another ethnic group. And this is very much felt in the US. So I hope this explains, but I suggest you go, you look at algorithmic sentencing on the internet, and you see it very complex ethical, first of all, ethical and philosophical questions on whether we want to substitute, to what extent can we somehow simplify the judicial machinery by introducing digital technologies. Now, reputational sanctions, Yazebol is asking, are there guarantees to protect the privacy of the individual? No, no. Once the person is on the media, there's very difficult. We find the only limitation we find in most Western countries is when the accused person is a minor, juvenile, a delinquent. So generally, the identity of the person is not given to the press, to the media. So this is one way for which you can protect it. There are other cases. We find, for example, in three countries, Switzerland, Germany, and Austria. This is interesting because it shows the model has circulated. It's a German model which has circulated among German-speaking countries, assuming that Switzerland is mostly German-speaking, by which the names of the people accused of a crime may not be given to the press. So we see that there's also that kind of protection. But generally speaking, apart from the idea of juvenile delinquents, which generally the names should be kept away, should not be given to the press, and these free countries where the name can be given if it is a very important crime, but not if it is a petty crime. If I have been arrested in Switzerland because I've tried to sort of steal some salmon from a supermarket, some expensive, or I've gone to a luxury shop and I've tried to escape with a foulard, well, it's a petty crime. Well, my name should not go on the press. But if it is a serious crime, if someone has committed a serious crime, typically murder, well, then there's a good reason for that everybody should know of the accusation. But generally speaking, in other countries, we find that there's no privacy of the accused person. Yes, Aori. Yes. You've raised your hand.
Well, now let's go on. Examples of reputational sanctions. There's quite a lot that interest in America is full of cases. For example, this is a state level. So someone, a postman who was stealing money out of the letters was forced to go in front of the post office with a placard saying, "I am a thief. I've stolen from money from the letters." So just they're being very harsh. Some examples, but these are typically folkloristic American approaches. But what we find is once someone is accused and has been accused of a crime, and this news reaches the media and the social media and the internet, well, that is a reputational sanction, and it is very difficult to separate the two elements. Again, I think the Weinstein case is very, very significant. Much before the trial, you will all know that this so-called Me Too movement came up, pointing the finger at Weinstein and a whole lot of other important people, mostly of the showbiz industry. And these people were accused of having sexual aggression or having sexually harassed, mostly, generally speaking, men towards women, but also in one case also men, homosexual harassment. So these people were immediately shunned and were forced to leave their jobs, to cease their activity. So this is, as you can see, this is a typical sanction, reputational sanction in the business community. Clearly, if a businessman is accused of improper behavior, obviously that businessman nobody will have activity with their businessman. So just to point out that this is also, this is a typical. Adimari is asking, can a country freeze a bank account when it was open abroad? Yes, well, through Interpol, yes, they can. This is quite common. Obviously, in countries which agree with Interpol, but this is what generally happens. The request for freezing a bank account is worldwide for all the countries where that agree with this judicial and police cooperation. So just to point out that this is, yes, that is quite common, and as a matter of fact, and we find them for serious crimes, money laundering, drug trafficking, and international terrorism. As a matter of fact, it's a typical area of European Union criminal law sanctions. But that is, so it is generally worldwide. Obviously, if someone keeps the money in North Korea or some tax haven, well, obviously that makes it much more difficult. But that is, the general rule is that the freezing is worldwide. If we know there are no more other questions, well, it's 5:45. Well, good afternoon to everybody, and see you tomorrow, and we'll end up with the criminal law, but I will devote much of the lesson also to criminology, which I think is a very important aspect in understanding what criminal law is all about. But we'll discuss that tomorrow. Good afternoon to everybody.